Hey, welcome everyone. We are going to kick off today's session for our teacher training series. And this one is communication with families on parent engagement with Selene Almazan. And I do want to just remind you, this is a webinar. And so you won't have your videos on, but you will need to go ahead and put any questions you have in the Q&A, and Selene is going to address all questions at the end of her session today. And I have put the handout in the chat. I'm going to go ahead and put that in again for anyone who joined after that. But anyway, Selene, thank you so much for being here today. We are so excited to have you and to go over this important topic. As we know, it's so important for us to make sure that we are communicating well with parents. And this topic has come up several times of how to get parents to engage more with, for their IEPs with their children. So thank you so much for being here. And I'm going to go ahead and turn it over to you.
All right. Thank you so much. And thank you for the invitation. I'm always happy to do stuff for Wyoming. And so thank you. My name is Selene Almazan, and I have been an attorney for almost 40 years representing families in special education matters. I am also the legal director for the Council of Parent Attorneys and Advocates, COPA, which is a national organization. I went to law school right after we got regulations for, as it's known now, the IDEA. I have 3 children. They're all adults now. I even have grandchildren. My eldest son had an IEP from the time he was from 2nd grade through the time that he graduated from high school. And my youngest son had a 504 plan. So I have sat in the parent chair and been the parent, and have been the parent that gets upset at 10 o'clock at night and drafts an email that you should never send when you're upset. So I feel like I was a sympathetic attorney before my son got an IEP, but I feel that it made me more of an empathetic attorney once he had the IEP and I got to occupy the IEP, the parent chair at the IEP team meeting. So I have a small private practice where I represent families in inclusion matters, families who want to stay in their neighborhood school. I'm in the East, in Maryland, and there are a lot of non-public or private schools that cater to students with disabilities, and many families want that for their students. I don't do that work. I work to keep kids in general education. I do work in Maryland. I've done work out in Nebraska, and right now I have a case in Oklahoma. So I sort of have a larger view of how this should work. Doesn't always work the way that it should, but I am a believer in the process and the process of the IEP system and the process of the rights that are given to families under the Individuals with Disabilities Education Act. So we're going to talk about the IDEA because I think it's important to look at what Congress intended for families to be able to obtain. And I know that we're going to talk about later on in the presentation about how to get families to engage and what to do. And when I talked to Deanna before the session today, we talked a little bit about ways to engage families, what to do when you have a dispute, so that it doesn't end up in mediation or in a hearing, but so that families come away feeling satisfied. And mainly, honestly, it really comes down to just feeling like family, like the parent has been heard at an IEP team meeting. So the IDEA was enacted in 1975 in response to litigation all across the country, I believe in 37 states, because there were state laws that barred the education of children with disabilities in public schools. There were many states in the United States that provided an education in buildings that were designed just for students with disabilities, but whether or not they had access to real curriculum is a real question. But there were a lot of states that had laws on the books that barred their participation and their entry into schools. It is, one of the things I think that we tend to forget is that many students with disabilities in the 50s and 60s and even the 70s, leading up to the 1980s, were institutionalized because there were no options for care for them. There were no options for education for them. And so many families place students into institutions. And honestly, that's how I started doing this work. I went to law school. I took a legal clinic, and the legal clinic was a developmental disabilities clinic. I honestly, to be honest with you, had really no idea what that was, but I knew I didn't want to do landlord and tenant work. So I chose that clinic, the developmental disabilities clinic, and they were the attorneys for deinstitutionalization of a institution where people with disabilities were housed. And part of the, I was in my 20s, had never been in an institution in my whole life, and went into this institution as part of the clinical program. And they were not allowed to have new admissions because they were trying to, place all of these adults and children and teenagers into the community in group homes. And so they were closing the institution. They were not allowed to have new admissions. And so they took us on the tour and we looked at the cottages, which were abysmal. And they took us into the nursery, and in the nursery were babies who looked like they had a disability, an obvious disability, and they were in these metal cribs with a metal crib on top with a lock. So it looked like they were babies in little tiny crib cages. And when I say that it changed my life, it changed my life. I had never seen anything like that. I thought to myself, it was so awful and an injustice. And I was I was young, and I was, like I said, in my 20s and had never seen anything like that before, and thought that I would change the world. And I still feel like that. And but that's how I ended up doing this work. And then, as it turns out, I ended up having two children. Well, I have three children, but two of them needed my help with education. So in 1975, after litigation all through the country, there were courts who said you have to let children with disabilities into public education. If you provide an education for children who do not have disabilities, you have to provide them with an education for children that do have disabilities. So that led to the legislation in 1975, and it is basically the federal government at that time promised up to 40% of federal funds if states would take the money to educate students with disabilities. We know that has never happened. I believe I was looking at a chart recently, and I think it was like 18% of federal funding back in the early 2000s, and it's back down to either 14 or 16% of federal funds. So it has never been fully funded the way that it was supposed to be funded back in the promise of 1975, but all states accepted IDEA money, which means that all states have an obligation to provide children with disabilities with an education. So in 1975, Congress found that there were more than 1 million children with disabilities that were being excluded from public schools. They talked about access to education. Remember, I said that the whole push, beginning with the litigation in the 1970s, was to get access to an education for children with disabilities. Congress talked about a couple of things with the what IDEA is supposed to do at the end of the day, right? Once a student exits education, it's supposed to prepare students with disabilities with employment and independent living, and also to prepare students for further education. And, you know, in almost the 40 years that I've been doing this, we have seen programs that are housed in colleges and universities for students with disabilities to access and experience the college life of living in a dorm, and getting independent living skills that way. So there are additional opportunities for students with disabilities in post-secondary that weren't there. Not in 1975, really not in the 1990s. And it wasn't until the late 2000s that we see all of these colleges and universities having programs for students with disabilities. The IDEA is supposed to protect the rights of children and their parents, and it is supposed to assist state and local agencies in providing an education through technical assistance. Also, it's supposed to assist states in providing early intervention services for infants and toddlers. That is the birth to 36 months or age 3. It's also supposed to improve the educational results for children with disabilities, as well as assess and ensure the effectiveness of education. So that seems really lofty, but the whole point is for students with disabilities to have access to education, to be able to be prepared for those 3 things: employment, independent living, or further education, to be assessed so that we know if they are receiving an education that provides them with those tools. So that is really the purpose of the IDEA. And you all know that one of the ways to measure education or measure whether a student is making progress is through the Individualized Education Program, the IEP. And that's a written statement for a child with a disability that is developed, reviewed, and revised in a meeting. And I think that this sort of information is important because you know, when we do these things, when we do IEP meetings on a day-to-day basis, or you're developing IEPs, it's important to really go back to look at what the law does require. And so the IEP is supposed to be developed, reviewed, and revised in a meeting. And then these citations here, that this is the statute that's really hard to read because it was, you know, drafted by lawyers. And then this is the regulations that are much easier to read and to understand. The IEP, we know, has to be in effect at the beginning of every year, each school year, and it has to be in effect before special education and related services are provided to an eligible student. So what does that mean? That means that you have to have an IEP at the beginning of every school year. There has to be an IEP that is either the one that was developed at the end of the last school year, or maybe it is carried over into the beginning of the school year, but it is still, you know, one annual year for the IEP. And we know that once a student is identified, they don't start to receive services until the IEP is agreed upon by a parent. And honestly, that very first IEP is really the only IEP that a parent has to give affirmative consent to. Because all the other IEPs after that, after the initial IEP, are IEPs for a student that's already receiving services. And if a parent disagrees with those services, unless you live in a consent state, which means that a parent has to affirmatively consent to things, it means that the only way that a parent can prevent something from happening that is in the IEP is for the parent to file for a mediation or a due process hearing in order to challenge what the IEP team has decided. So that is important. And I think that that is something that is hard for families to understand, that there is no way to prevent the implementation of an IEP if they don't agree with it, because they have to do something about it. It is not incumbent upon the school to do something about it. It's incumbent upon the parent to do something about it. And I think that that can be really confusing and can also lead to a lot of distrust at the IEP team table if families don't understand that piece of it. The IEP has to have an explanation of the extent to which a student is not going to participate with students who do not have disabilities. So it has to have that kind of information in it. It also has to have information about any kind of modifications to district-wide assessments that are necessary for a student to participate in those assessments. And that's important because I think it is important to assess students with disabilities to determine whether or not they are making the progress that they're supposed to make as compared to their non-disabled peers. And there has to be some information that parents can rely on through the process of assessments. And I know that that's not really a popular viewpoint among some parents and advocates, but I think it's important to have assessments to help guide education for students with disabilities, just like it guides education for students without disabilities. The IEP has to have a progress statement. And when I go to IEP meetings with families, this is really important. This is really how you're going to measure and convey to a family how the student is progressing. And it's important in IEP teams meetings to explain to families how you're going to measure that progress. And so I think that what gets confusing for families and where families get upset is when you have 3 out of 5 trials or 80% or 75% and an explanation of how you're going to measure 3 out of 5 trials or how you're going to measure 80%. Is it 80% of each time you try the activity in the goal or short-term objective? Is that the 80%? Is it 80% out of the week for each time you introduce the short-term objective? So an explanation that families can understand, I think, goes a long way to ensuring that they buy into the IEP and its components so that they understand what is expected of their child in school. And it's really all about the explanations. I really do think that that's really a lot of the key to engaging families so that they understand. Because honestly, at IEP team meetings, it is like we all speak a different language. And even I do that with the acronyms that we have and the understanding about how curriculum works. Families generally do not have that kind of understanding. So as much as can be explained to families at the table, I think that that goes a long way to assuring them that you have obviously their child's best interest at heart, but also are invested like they are in making sure that the student is challenged and is making progress. The IEP has to have a statement about aid services and other supports that are going to be in the IEP so that students can participate in general education curriculum. And this definition was never in the IDEA until 1997. So that's like over 20 years later, they finally got a definition of supplementary aids and services in the law. The IEP has to be implemented as soon as possible following IEP meetings. And what does that mean? I think we get guidance from local state departments of education on what as soon as possible means. In Maryland, where I live and practice, there is guidance that as soon as possible can mean 30 days for implementation, 3 weeks for implementation, but the closest that we have to day counting in the law is as soon as possible. And obviously the IEP has to be available to the teachers or other service providers that are going to be teaching the child. The IEP team has to ensure that everybody that should be at an IEP meeting is there, and that the IEP is reviewed at least annually, and that if there is a lack of progress, that the IEP is revised to address any kind of lack of progress, and that parents are equal participants. The law does require that parents are equal participants and are supposed to participate in a meaningful way in the IEP team meeting. This issue of revising the IEP because of a lack of progress, I think is really crucial. I know that IEP team meetings can be very time consuming, but if you have a student who is not making any progress and a parent who is asking questions about a lack of progress, or even about grades, or even about related services like occupational therapy or physical therapy or speech therapy, that the IEP team really should be convened in order to address those concerns that a parent might raise about a lack of progress. IEP team members really should bring information to the IEP team about the student's strengths and needs, their learning style, what their interests and motivations are, interactions with peers, successful strategies and supports. These are not required in the law, but it's something that I came up with because of all of the hundreds and thousands of IEP meetings that I've attended for clients through the years, and also for my own son. I remember when we first started doing IEP meetings for him at the local elementary school, and the principal at the time made every team member say one positive thing about my son. And honestly, that was really meaningful. I was really reflecting on it the other day for some reason. He's 38 now. And so this goes all the way back to when he was 7, but just really reflecting on what that meant to me and what the tone that it set for a team to talk about what those strengths are. And when I attend meetings with families, I try to emulate that. And I ask, can you tell me some of the student's strengths? Does he come to school every day? Does he bring his materials with him every day? Does he follow directions to get in line? But I think that talking about those strengths, I think, is really important because we know that students with disabilities are more than their disability. They're children first. And I know you all know that, but I think that sometimes I can tend to forget that when I'm in an IEP meeting with the family, that they are children first. And that goes a long way to helping families feel more comfortable and feel that you see their child as a child first. Okay. The IDEA requires that the general education teacher participate in the development, review, and revision of a student's IEP, and also talk about the assistance in determining any appropriate positive behavior interventions and strategies, and also contribute to the discussion or the determination of any supplementary aids and services or any kind of program modification or support for school personnel that are required by the law. Program modifications are what changes can we make to the program to accommodate the student, and what kind of supports do the teachers need in order to educate the student. And those are all discussions that should be had at the IEP team meeting. The IEP team has a variety of functions. I see it really as a communication vehicle to talk about a student and the opportunity to make informed joint decisions about needs and goals and how they're going to participate in the general curriculum, how they're, what kind of supportive services they might need. And I am one of those people who does enjoy going to IEP meetings because I do see it as a way to problem solve, and try to figure out what a student needs and how that can be accommodated for that student, and really to ensure that the school team members are listening to what the family is asking for, or to ensure that if you have a situation where the trust has broken down between the parent and the school, I see my role as trying to figure that out and helping bridge that, distrust that develops when people feel that they're not being heard, and make it smoother on both sides, for everybody, so that the student benefits. Because when parents and schools are at loggerheads, we have to get back to talking about the student and what the student needs. And I'm a firm believer in that. We really need to focus on what a student needs. And yeah, so I'll get back to that in a second when we go through the rest of the slides. But parental notice, you all know that you have to give it early enough to allow the family to come. It has to be at a mutually convenient time and place. And, if there is an emergency, then obviously you have to have the IEP team meeting if there is an emergency in the case of discipline, and suspension and possible expulsion. Parents are entitled to a written notice about the meeting, what the purpose is, the date, time, and location, the people who are invited, along with their titles, and informing the family that they have the right to invite people that have knowledge or expertise, as well as offering accommodations and language translation, which I didn't have on this slide, but that's also important. An IEP team meeting agenda, I was looking through I was looking for cases and letters of finding and guidance when I was preparing for this last week. And the purpose of a meeting agenda is to keep things on track, right? I don't think putting time limits on it is necessarily a good thing, because oftentimes it is left for families to just talk for like 2 to 3 minutes. I've actually been to IEP meetings where the family's portion is only 2 to 3 minutes, which we know breeds distrust, and we know inhibits the parents' participation and involvement. So it's important to have an agenda, but I don't think it's good to have the time on there, how many minutes a parent is allowed to speak. I think it's important in the beginning to do the introductions, as well as the purpose of the meeting, so that families understand why they're there and what you hope to accomplish. And the agenda can include reviewing the draft goals and objectives, approving the goals and objectives, what the special education placement is going to be, determine whether or not the student is eligible for extended school year services. If the student is of the age of 16, transition planning. I think it's always good to offer a family an opportunity for another review meeting to look at progress. If you want to engage families, I think that that's always important. Doesn't have to be a long meeting, but just a meeting to check in to see how progress is going. So I did look at a couple of cases, and there are a lot of cases about families refusing to participate and families who want to say exactly, families who come to meetings and say, this is my bottom line and I don't want anything beyond that. This is all that I want. You have to come to a meeting with an open mind. And there is a case out of New York where the court found that the New York district did not violate the IDEA when it denied a father's request to place a student with autism in an out-of-state private school that used natural methods to educate children with developmental delays. The right to participate in decisions about a child's placement does not include the right for a parent to say, I want this specific school and nothing else. You have to make those kinds of placement decisions based on the IEP. If a parent doesn't agree, then they have their due process procedures, but they don't get to say that that is the only thing that they want. There was another case out of California and another one out of Illinois about trying to accommodate families who might speak another language, and whether or not it allows them to participate in a meaningful way. So to ensure that the IEP team considers a parent's input, a district may need to provide accommodations so that a parent can participate in a meaningful way and provide input. So you do need to make sure that they have access to the information in the language that they might need, or if they might need ASL, American Sign Language or something like that, those accommodations need to be made. And districts must make substantial efforts to secure parent attendance at the meetings, and that includes alternative means such as by video conferencing or telephone conference calls. So since the pandemic, I believe that we've all gotten used to doing IEP meetings virtually. That should be an option for families who perhaps can't make it in person. I agree that it is awkward when everybody else is in person and the parent is virtual, but at least they're there participating. And I think that that's important. So, I've represented families who are so dejected over how a school is, school placement is going, particularly when students have challenging behaviors that lead to suspensions. That I had a client in the last 2 years who didn't want to come in person to meetings. And so we were in there, in the meeting virtually. And if you're the only one that's there virtually, I think it makes it a little hard to participate completely, but at least the parent is there and participating in some fashion versus declining just to not to attend the meeting. And refusing to attend a meeting is never a good strategy for a family. So special education is defined in the IDEA. And I mention this because there's a lot of confusion about what it means. And special education is defined, and it's defined as specially designed instruction at no cost to the parents to meet the unique needs of a child with a disability. And then specially designed instruction is also defined. And specially designed instruction means adapting as appropriate to the needs of an eligible child, the content, methodology, or delivery of instruction. And I think this is really important because if you look at the definition of specially designed instruction, you can talk about methodology, and if families want a certain reading instruction, that is something that the IEP team should discuss so that the parent can feel that that their requests are heard. You shouldn't shut down a conversation because you believe that you're talking about methodology, and the erroneous belief that you cannot talk about methodology at the IEP team table. That is erroneous. The definition of special education is specially designed instruction, and specially designed instruction allows you to talk about methodology. Doesn't mean that you have to agree to provide that methodology, but you do need to allow the discussion to happen. Andrew F. was the United States Supreme Court case that addressed again what the definition of a free appropriate public education is. And the Supreme Court, in their unanimous decision, said that the input of the child's parents is just as important as a school district's personnel. And so that's really important. They also talked about the importance of meeting to address the lack of progress, because in Andrew F., that school system did not meet to address that lack of progress. And this is in your circuit. This was the 10th Circuit. This was a case out of Colorado. Andrew F. was a student who had autism and had a significant amount of behaviors. The parents wanted a functional behavior assessment, and they wanted a behavior plan, and they wanted goals related to the behavior in the IEP. The school district declined to do that. They came to an impasse. The family withdrew him and placed him in a private school called Firefly, where Firefly developed goals for him, addressing the behavior, also developed a behavior intervention plan based on a functional behavior assessment, and it worked, and his behaviors were under control. The family tried to go back to their neighborhood comprehensive school and said, we have the behaviors under control because of this behavior plan. We would like for him to return to his neighborhood general education building. And the school district declined to provide him with a behavior plan, declined to change the IEP to include behavior goals. And that was in error. They should have made changes to the IEP. I never understood that part of this case. How come they dug in and just didn't do it? But at any rate, eventually the family did win. They went all the way up to the Supreme Court, and they got the reimbursement for the Firefly placement. But it really was one of those instances where you look at it and you think, how come they just didn't revise the IEP? And I don't know, because I think that we tend to get stuck in our positions, and sometimes that's not a good thing. So dispute resolution. I'll talk about this a little bit. Strategies for getting to consensus. Listen to the parents' concerns, provide all the information that the team is considering. Don't give any surprises at the IEP team meeting, things that you've never told the family before. Anticipate any kinds of parental questions so that the whole team is prepared. Come back for another day if the meeting gets too heated, and provide data to the parents with some kind of explanation of what the data means. I've had in all the years I've been doing this, I've had the situation where families get really upset and leave, or get really upset and completely shut down. And that's never fun if a parent is not communicative at all in the IEP team meeting. If that happens, I know it's a pain, but I think it's best to adjourn the meeting and then come back when people are feeling better about participating. There are other options for dispute resolution, such as a facilitated IEP meeting, mediation. You can ask for mediation only as a family. You don't necessarily have to file for due process. Parents can file a state complaint, and then the school team will have to address that. But those are all things that families can do in order to try to resolve things. But really, it's easier to resolve things at the IEP team meeting. There was a case I found from 2017. I believe it's from, hold on one second, Colorado. Again, the 10th Circuit explained that the failure to object to IEP team decisions until 2 years after the IEP meeting constitutes a waiver, forfeiture of claims. So if a family doesn't agree until years later, those claims are not going to be able to go forward for a variety of reasons, whether it's the statute of limitations or whether their failure to object means that they waived it or walked away from those claims. So that is why it is always good to try to hash things out at meetings. We know that emotions are always high for a parent. The meeting is about their child, and it can be legitimately difficult. When I first started going to IP meetings for my eldest son, I always felt like there was a train in my head. I really couldn't concentrate. And I'd already been an attorney for over 10 years at that point, and specializing in this area of law. But it was very hard for me to hear the things that the team said that my son was never going to be able to do. And so that was very difficult. Encourage parents to ask questions and encourage them to bring someone with them for support, because it is lonely just being that one parent. But if they have support, maybe you get someone who is able to not interpret in like there's a foreign language, but like interpret it for the family to understand. Give parents enough notice and options for an IEP meeting. If they want the opportunity to attend virtually, allow them to do that, and make sure that you as school staff document your communication attempts, so that if it ends up in a dispute resolution position, you are able to document what those communication attempts were, because that's important, because it's you need to have some sort of paper trail and also documentation that you try to communicate, you try to invite, you try to engage the parent, and they declined to engage. In the materials that accompany this PowerPoint, there is a section in there that talks about the Doug C. case from Hawaii, about a school team that tried to get a parent to participate and tried to get a parent to participate, and the parent would cancel the meeting, and they would set another meeting and the parent would cancel again. And the Ninth Circuit said you must have the parent participate in the IEP team meetings before you can go on to develop the IEP. And then there is this case out of the Sixth Circuit, which is a deal, that said that the failure to provide for meaningful participation by parents in the IEP process may result in denial of FAPE. And this case was more than about the parental participation. It was about, who was at the IEP meeting, but You can see how important courts view the participation of parents in the IEP team process. Be mindful that it is overwhelming to be presented with the information at a meeting. And if it's possible at all, provide drafts, if possible, for families before the meeting so that they can digest the information and ask questions before the meeting and during the meeting. Because otherwise it is very hard to digest that information. A collaborative partnership between parents and educators fosters a more comprehensive approach to a child's education. Again, I really do feel that the IEP meeting is the opportunity to come together to problem solve for a student, and you know, come together so that everybody feels that they're on the same team with the student at the head of that team, because that's really what it's all about. Um, uh, uh, One thing that when I was preparing for this, one tip that I saw was inform families at the IEP meeting what your preferred mode of communication is. And because you all are teaching, you can't check email during the day. And say that, you make a plan for a preferred communication method, whether that's by phone or an email later on, at the end of the day or at the end of the week, and establish a communication plan in the IEP or in the 504 plan. Instead of asking, do you have any questions, ask, is there any aspect of this you want me to clarify? And encourage parent training as a related service on the IEP. If you are frustrated with a family you believe doesn't understand the scope of the disability or is not engaging in the IEP process, and then sometimes acknowledging a mistake goes a long way to maintain a relationship with the family. And I think that's it. I'm like 1 minute over. So let me stop sharing and I will open it up to questions.
So again, if
Anybody?
you have any questions, if you'll please put it in the Q&A and we'll be able to pull those from there. I do not see any so far. I have also, I'm getting ready to post the evaluation for this session. If you could please make sure you fill that out. It really does help to drive future training and help us to know what your needs are. I will also be putting in the chat the link to the virtual trainings that are upcoming so that you can be registered for those and the dates.
Okay. I see 2 questions in the Q&A. Tanya asked, is Wyoming a consent state? No, it is not. A consent state is, I think there's only a handful of consent states. Maryland is a consent state. Oh, then they just ran right out of my head. I think Massachusetts is also a consent state, and so Florida is a consent state. So there are certain state laws that say if a parent doesn't agree to place their child on an alternate assessment, the parent if the IEP team says the child has to be placed on alternate assessment or alternate learning standards, and the parent does not agree, the parent has to affirmatively consent to that. And if they do not consent, then it is the school's responsibility to go to a hearing or mediation to prove that the student should be on the alternate learning standards. Oklahoma is also a recent consent state. Maryland is a consent state for alternate assessment, but also for placing restraint and seclusion on an IEP. If parents do not agree to restraint and seclusion on an IEP, they have to affirmatively consent to that. And if they do not, and if the school really thinks that that is something that should be on the IEP, they can take the parent to a hearing. And the reason why that matters is that then whoever files for the hearing, if you don't live in a state where the school district has the burden of proof, like in New Jersey and New York, where the school district has the burden of proof, and in New Hampshire, then the school district would have the burden of proof to prove that a student needs to be on the alternate assessment or alternate learning standards or needs the restraint and seclusion on their IEP. That's what a consent state is. And it is something that's above and beyond what the federal law gives, and that's appropriate. States can do that, and there are some people who like the opportunity, like the idea of a consent state. The consent, putting the onus to consent on the parent. But there are timelines, and if a parent doesn't return the form in time, then it can happen. The student will go on the alternative assessment, or the restraint and seclusion will be placed, or like in Florida, if the recommendation is to put a student in a more restrictive placement, like a self-contained classroom, and the parent does not consent to that or lets the time lapse, then that can happen.
Thank you. While you read this one, I'm going to answer the last two questions that were in. It was about the recording, and there will be a recording that will be posted, and I'm getting ready to hit enter into that one so that you guys can access the recording, and the slides will be available there, as well as the handout will be available at this site.
Okay. When students are 18 and involved in the process, what suggestions do you have to support the student in understanding and self-advocating when their behaviors may cause suspensions reaching manifestation? Well, I think you could look at counseling services for the student that are provided. You could look at developing some kind of behavior intervention plan based on a functional behavior assessment. If you have some key behaviors that are leading to behaviors that may be a manifestation, in order to help the student develop skills. That's what a behavior plan is supposed to do, is teach alternative behaviors to address whatever need that student might have, and what they're trying to communicate. Having the student be involved in the development of IEP goals, have the student identify what those issues might be for them, like what kinds of behaviors do you think will lead you to get a suspension, and what can we do to address that? What could we have done differently in this situation? Let's talk about some short-term objectives. Let's talk about some goals to get you there, and let's task analyze how we're going to get you to where you need to be so that these things aren't happening anymore. You might look at a reward system as far as, tangible things like being able to have a field trip, or be able to purchase items if that's an issue, that they want, or earn their way to an item during the school day. I hope that was, yeah. Those are the suggestions. You need to obviously have them buy into it. It's like my 4-year-old grandson. I told my son the other day, well, when you put him to bed, you didn't want him to do that. Maybe talk to him about what could he have done differently. And he said, oh, that's what you used to do with me. And I was like, well, yeah, it works sometimes and sometimes it doesn't, right? But yeah, talk to them. I don't think, and I have this belief system for years, is that kids don't go to school so that they get in trouble. They don't. They want and need adult affirmation, and they might need attention, and using the wrong strategies to get that attention, or they want to avoid work and they're using the wrong strategies to avoid that work. But they don't go to school. They don't wake up every day and say, I think I'm going to get in trouble in school. I don't think that that's how kids are wired or how adults are wired. So.
Any other questions while we have Selene with us for the next few minutes? If not, once again, you can access all of this information on the site that I posted in the chat. And please do take time to fill out that evaluation for us so that we can use that information to move forward.
Thank
Selene,
you all.
thank you so much.
Oh, no, thank you.
We love having you, and we look forward to next time. Oh,
All right.
we have
Okay.
one last question here.
Sure. Is there a certain number of attempts for families to attend a meeting before moving forward without them? No. No. But if you're going to make consequential decisions at that IEP team meeting, I think you need to really document how many times you tried to get them there. I think you need to try to get them virtually or on the phone, or see if they will sit down just with you to go over the IEP meeting discussion and the recommendations. It really comes down to how much you tried to get them there, and you have to document all of that. And if you're going to make a consequential decision and you know that you are, then the documentation, I think, is even more important, and trying to get them to engage and at least going over it with you after the IEP meeting and telling them what their procedural rights are again, in order to get them engaged. In the 24 pages of material, I put together something for you all. Look at that Doug C. case and the explanation, and they really tried to get him to the meeting and he kept on canceling it. And, the appeals court finally said they shouldn't have ever had the meeting without him, even though it appeared that the school really did try to get him there. Does that count as them attending the meeting if you visit with them after? No, Trisha, it does not. It doesn't, but at least you're trying to get them to understand what you have decided. How would you start a conversation with parents about their child seeming to need after-school tutoring? That you all are going to provide? You all are going to provide the after-school tutoring? Yes. If yes, I think talk about, okay, what you see the student needing at that time, and ways to make the student more successful. And maybe, I'm just thinking information like where you would want the student to be, because you know that that student is capable of doing X, Y, and Z, and they just need that additional after school tutoring. I know that I just saw this recently. I know that a lot of people view the after school as more of a punishment because, kids get tired, but we're not talking about after school tutoring every day. We're talking a supplemental thing for them so that they can be successful. I think I would frame it as, we want him to be successful, and this is a way for them to be successful. That does not take away all the other things that he is doing in school. I think that's how I would frame it.
All right. Well, thank you all for your questions, and thank you so much, Selene, for taking a moment to engage in those and answering those questions as well. We will have the recording will capture all of the questions, and so yes, you will have access to the answers on that as well. So make sure you go back and watch that recording. And
Okay.
with that, Selene, have a
Thank
wonderful
you.
evening.
Thank
Tell your
you.
husband happy
I
birthday.
will. I will. Thank you so much. Thank you all for coming. I appreciate it. Thank you.